Thank you for joining us. We have John Smith here who is going to be providing a minor guardianship training. And now this training was originally done at the courthouse. Um, and we're going to go ahead and do this today live and save it so that if anyone on here needs to go back in, has questions, maybe they'll be answered through this video. And I'll go ahead and start sharing my screen. And let me see here. Can you see that, John?
Yes, it shows up well for me. Thank you. Let me know when you're ready for me to start.
You can go ahead.
Okay, thank you. Welcome all of you out there in video land. We get to do things differently these days, so hopefully it's kind of fun and it's working for you. I'm the one that's going to make the presentation to you about minor guardianship training. My name really is John Smith, believe it or not. I'm an elder law attorney in town who does mostly adult guardianship, but I have a passion for juvenile guardianship, or minor guardianship as it's called, as well. So I get to do your training and we'll have a little fun today. Also, there will be time at the end for questions if you have them, and we'll try and walk you through how you do that when we get to the end of the presentation. So as you can tell by your screen, hopefully this is going to be a little entertaining because you're looking at a picture of a snake that swallowed something and wondering, well, maybe I shouldn't have eaten that. I hope none of you feel like that. But when I do this training live, I want to share with you something that I've normally done that I think that's very telling for us. I will usually ask the number of participants who are grandparents to raise their hands. And if we were a little more sophisticated, we have a way to do that here. But I'm just going to share with you that it's been my experience that 80 to 90% of the people that become guardians for minors are grandparents. And I'm very reassured by that for several reasons. Number one, you've done this before. So you have some experience and you know about things that work and things that don't work. But I also want to say thank you to all of you that are participating in this who have stepped up and taken responsibility for your young person. The court very much appreciates and supports that, as you will find as we go through this training today. So we're going to talk today primarily about two areas. What is your authority as a guardian, and what is your responsibility as a guardian? And we're hopeful that if we bring more clarity to this process for you, you'll be more comfortable in your role as guardian in knowing what we're expecting of you and how we kind of get that done. So, all right. Well, Edith has popped up the next slide, and now you're officially welcomed. We would normally introduce ourselves here, but we're not going to do that in this format today, unfortunately. But again, welcome, and we're going to move right along. So Edith, if you want to go to the next slide. Introductions, good. The disclaimer of legal advice. What we're saying here is I'm not giving anyone today specific legal advice about their case. And if you need that, my first suggestion to you is to go to the court, because the court is really your friend and a sponsor and the one who gave you the authority. And so I always say, go to them first and see if they recommend that you get some specific legal advice. Many times they can help you with the everyday matters of guardianship that come up, and hopefully you'll never really need hard legal advice. Okay, let's move on, Edith. Okay, here's a definition of guardianship. Please take a minute and read through it, and then I'll make a couple of comments before we move on. Okay, good. I hope you'll notice that in the bottom definition, we call the minors protected persons. I used to have fun with my audiences when I did this live because I would ask them, what did they used to be called? Because not so long ago, they were called by a different name legally. And some people will remember that. And the term that used to be applied was called ward. And you've probably heard in the movies or someplace when someone was called a ward of the state. Well, now they've changed that to be more of a kinder, gentler description. And so they call them protected persons. So I think that's a good definition because that's primarily what the court is asking you to do, is to protect them and take care of them. By these definitions, I hope you understand and appreciate that essentially you have been given the authority of a parent to make decisions for your young people. And we'll go into more depth in that as we go on through the rest of these slides. If you have questions on these things as I'm going through them, please take a moment and write it down someplace so at the end you'll have the opportunity to bring that up and we can get you some answers or some resources. Edith, I'm ready to move on. Okay, first we want you to be aware of what the law says about your authority and responsibilities are. There's actually 2 chapters of Nevada Revised Statutes that apply to guardians. The main one is chapter 159, and that's really adult guardianship. Now, the last legislature in 2019 took all of the sections that apply to minor guardianships out of 159 and put them into a brand new chapter called 159A. And then in the handouts that you have and you see on the screen, there's a specific address that you can go to if you want to review that or go through it online. You can if you need to, but hopefully I would say that in most cases, you won't have to consult that. You could consult the court, or maybe we'll be able to give you the information you need today in this presentation. So it asks you to familiarize yourself with the laws as it governs your duties, but that's part of my job today. And I think in filling out the paperwork and going to court and answering the questions, you probably have a pretty good idea already of what your duties are. At the very bottom, it says, note, this is never a substitute for qualified legal counsel. Now, the court can't give you legal advice. It can give you practical advice, direct you to resources, provide you forms and things like that. But always in my recommendation, before going and getting legal advice, go to the court. The court wants to help you. The court wants to support you in doing the duties now that you're legally responsible for. And so they can probably save you a lot of time, trouble, and energy if you'll just go to them first. All right, Edith, let's go to the next slide. Legal lingo, and I'm just going to ask you, Edith, to bring them all up there. There we go. These are all the little descriptions of orders and processes. So we've got pleadings and petitions and citations and due process. Most of you have a pretty good idea of what that is. And if not, we can ask a question at the end and I'll give you a specific one. But I always want people to understand, of all the terms that are there, which one is the most important for you. And many times people will say, oh, it's the order because the order granted me the authority of a guardian. Well, that's logical, but as it turns out, it's really not practical. Because when you take your young person to a doctor or to the school district or some other services, they're usually not going to ask you for a copy of the order. They're going to ask you for a copy of the letters of guardianship. Interesting term. You all have them now. When you were awarded guardian of your younger person, the court gave you that document called letters of guardianship. And it also has a court seal on it that is certifying and authorizing that this is a true document from the court. So what I recommend is you keep that with you whenever you're going to go and request services for your young person from a school or from a doctor or something, but never, 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 never let somebody take that original copy for you. Because if they do, then you're going to have to go back to the court and get a new one, and that costs $5. You can let them make a copy of it, but I would suggest that you hold on to your letters. Now, the reason I think letters shouldn't be the most important form and orders should is because orders details A, B, C, D, what your authority is. The letters don't do that. But as a practical matter, for people that you're going to interact with, for your younger person, they're always just going to ask for the letters. So make sure you keep a copy of those handy. Okay, let's move on to the next slide. Guardian of a minor. Here's another little thing. Just take a second and read that over and we'll chat for a minute about it. All right, good. Now that seems pretty straightforward, but you know, in the law, sometimes we ask kind of trick questions. So I might ask you, what is the age of majority? And if you just jumped right up and said 18, I'd say, aha, I gotcha. Because what the term on the slide is trying to say to you is you're a guardian of a minor if the minor is under a certain age. And the legal age in Nevada is 18. But what you're going to find as we go through this presentation is there are exceptions to that, and we'll point those out to you. But by and large, you'll notice at the bottom, you're given two basic responsibilities: to provide for the basic needs of your younger person and for their safety. And you may begin to think, well, that's kind of obvious, and it makes a lot of sense to me, and isn't that the same thing that a parent does? Well, yes, it is. And matter of fact, in some places, you're called a type of parent legally. Right now, the term that we use is guardian. So let's dig a little deeper on some of these and see what some of the specific things are that we're going to have to discuss. Go ahead, Edith. Okay, a protected minor. Here we go. Now it says, there you go, less than 18 or less than 19 if the guardianship is continued until the person reaches the age of 19 years pursuant to, and it gives you a statute. Well, don't run to the statute and look that up. I'll tell you what it is. If your young person is still in high school, the guardianship can be continued until they complete any particular program that they are in high school, at least to the age of 19, and in some cases, all the way up to the age of 22. So lest you think that your guardianship is going to expire because your young person is going to turn 18 and they're still in high school, don't worry about that. The court will be giving you instructions about dealing with that if that situation happens to you. And we'll talk a little bit more as we go through that process on the next slide. Okay, needs, alternatives, and rights. Oh my. Well, we were trying to have a sense of humor here a little bit for some of you in the audience that are old enough to remember a movie that has a famous saying like that. And usually when I start bringing that up, someone will say, oh, lions and tigers and bears. Oh my, it's from The Wizard of Oz. Hopefully you're not having that kind of an experience, but yes, being a guardian is a serious matter. And so the court has some expectations on you exercising your authorities to protect the younger person that you have. And there's some specific things we want to discuss at the bottom of this slide. Determine residence. You now, as guardian, are responsible for determining where that young person resides. Now, I usually get some questions here immediately because if you're that person's guardian, then that means probably a parent may or may not be involved in the mix of everything else. And what do we do with the parents' rights? Well, legally, if the parental rights have not been removed by an order of the court, the parents still have rights. But your rights are superior to their rights at this point, and that's why the court has made you guardian. So it is you who determines where that younger person should reside, and not the parent, not the child, not anybody else related to that person. And if you have any questions about that or an issue comes up with that, bring it to the attention of the court and they can help you. You also have the responsibility to address educational needs. And probably if I asked you live what that would be, wouldn't take you very long to come up with, oh, I've got to make sure they're in school. That's correct. Unless you're a qualified homeschool person, they need to be in school. Now, these days, we're not sure if school is going to be live or distance training or what it is, but it's still your responsibility to the extent that you can, that you see they have the opportunity to participate in education heading towards at least that high school diploma level. All right. Consent to medical treatment. I'm going to save this one for a little bit because we have a slide a little bit later that covers this. And we also have a slide about determining appropriate visitation, which we'll go into in much greater depth in a future slide. Lastly, and the one that I kind of like among all of these, is you get the one to determine what is in the best interest of the child or children, if that's the case. So it isn't the child making that decision. It isn't a parent making that decision or a grandparent or anybody else. Now, you may have people that think they know more than you about what's in a child's best interest, but the law says you are the one that makes that call, just as you would if you were a parent. And that's what the court is asking you to do, is use your best judgment to determine if something is in the best interest of the young person that you have responsibility for. Okay, let's move on with this one. Okay, warnings, facts, etc., etc. Looks like we're back to lions, tigers, and bears, doesn't it? Well, let's dig into this and see what we're going to talk about specifically. All right, we have some definitions up on the screen of different kinds of abuse, basically. I'd like you to take a moment, read those over, and then we're going to chat a little bit about them and what the purpose of this slide is. Okay, I think you've got the gist of what's going up here on this screen presentation slide. What I want to bring to your attention is we don't expect you to know all these definitions so that you can not do the things that they describe. So we're not wagging our finger at you and saying, don't do these things. In my view, we're trying to make you aware of what those things actually are. And the main reason I think we do that is because you have other people that are concerned about the young person that you're in charge of. They probably will have a different opinion many times than what you have about how someone is being cared for. And let me just give you a common example that I think will show you where I'm headed here. You may have a parent that thinks that their visitation rights should be much broader than what you think they are. But it's your responsibility to decide that. However, when you make that decision, it's not uncommon for us to see a parent or a grandparent come at you and say, wait a minute, that's abuse. They need to be able to see me for 4 weeks in the summer and every other Christmas and on and on and on. And they will use that word abuse because that's a trigger word in our culture and society today. And when people start going after you and pointing at you and saying that's abuse, I think the court wants you to know what it is and what it isn't so that you will not be intimidated by that, because you're the one who decides what is going to be in that child's best interest, and the court will respect your decision. The court does not want you intimidated by threats of abuse. And certainly if you have questions on this, write them down. We'll try and catch them at the end. But let's move on to our next slide. Okay, emotional aspects of guardianship. It's very likely that your younger person has been through some difficult times, and they may have come through those difficult times with behavioral challenges, the remnants of family dysfunction, specific behaviors like anger, et cetera, et cetera. A lot of those things are normal for a young person, and most of you have been parents before, so you know that most kids will come through that. They'll figure it out, they'll get better, they'll move on, particularly when they're in a supportive and protected environment like you will be providing them. But if they don't move on, if they continue to have challenges, if it causes problems in school, what the court wants you to know is there are significant resources available to you that can be provided at no cost to help that child, particularly counseling. A lot of those resources, if you want to know about them, we'll cover some of them at the end of the presentation, but also you can always call Nevada Legal Services. They know the people that handle those sorts of things that are school related or home related or those sort of things. So I guess the point is, if you feel like this is not working out, you don't have to stay in the boat until the boat sinks. Help is available, and no one's going to fault you for asking for some help that maybe is apparent in a particular situation. Okay, let's go to the next one. Interactions. Okay, being a guardian is a serious responsibility. And the court wants you to know that its expectation is that you will have interactions with the people that are important to your young person's well-being. If you look at the little categories on the left side of your screen, doctors and medical professionals, that's probably common sense. You want to go to their doctor's appointments, see what's being said or what's being recommended or what's going on. Social services, probably for most of you, any interaction with social services has gone down to almost nothing unless there's maybe periodic visitations. But that's something where you should be present and know what's happening and ask questions as well. Financial professionals, if there's assets, which we'll talk about in greater detail this afternoon, you need to be involved with the finances that young person may need you to manage for their benefit. Teachers, obviously. Therapists, obviously. Attorneys, I hope not. But if attorney's going to be involved, you're their legal representative. So yes, you need to be involved. I think that's all I have to say about that one. It's kind of common sense, but just kind of walked through it. Let's go to the next slide, Edith. Okay, I am the guardian, and what do I do now? Here's some specific things that you as guardian need to do so that the court continues to be informed about your progress as a guardian. You have received copies of a form called an annual report, and we'll talk about that in detail. We have a special slide for it. You may or may not have received forms for inventory and record of value, but we have a slide for that one, and we'll go through that one, as well as annual accountings if you're caring for the finances of your younger person. But record keeping, there's some specific things on that one, and yes, we have a specific slide just for record keeping. Appropriate financial management and bookkeeping processes, we have a slide on bookkeeping processes, so we'll go in that in more depth. Actions for which court approval is required, and notices that the court wants a change of address, we'll go over those in specific detail and the most common ones that come up, so you'll know where you stand on those. So almost all of those, we have specific slides that we're going to go through for each one. So let's get started. Guardian of the person. All of you should be guardian of the person. That means you're responsible for the person of that younger person, their medical care, their educational needs, all those things that you see down there, providing a safe and affordable living arrangement, personal care. But I want you to focus on the one that's on the bottom. Meeting all basic needs to ensure the highest quality of life within the limitations of the available services and resources. That means your young person may want a Nintendo 17, but if that's not within your financial resources, then that's not something that you're required to do. You're only required to do the best you can with what you have. And so there is no expectation there that you try and maintain the standard that your young person used to have or would like to have. Okay, let's go to the next one here. Annual reports. Here's our slide on annual reports. The form that you received has to be filed once a year within 60 days of the date that you became a guardian. So you can go and mark your calendar or put a little reminder in your phone or on your computer that when it's time for your annual review of this guardianship, you have to fill out an annual report and file it with the court. Now, if you've looked at the form that's there, you'll know it's some pretty common sense kind of stuff. It's, you know, how are they doing in school? How are they doing physically, mentally? It's all the things that someone who has an interest in that young person may want to know. And for most people, they fill those out by handwriting or printing. And hopefully, as long as it's readable, you're not going to have a problem there. But I want to talk for a second about the purpose of the annual report. Certainly, the court who granted you your authority has an interest in making sure that everything's going okay. That's basically it. So when you fill that out, I want you to think like you're the court. What would the court want to know if I said, well, we've moved 6 times last year? The court would probably want to know why. So even if you only have one line to write something down, you can still attach a separate page and say, here are the reasons that we changed residences so many times, or we changed schools, or we changed doctors. Just put yourself in the feet of the judge there and say, what would he want to know more about? And more is usually better than less. And I also say, look at that report that you're filling out. Are there any red flags in there? Is there anything in there that may cause the court to say, oh, we're going to need to have a conversation about this? You can do that if you want, but if you already have an explanation, I suggest just writing it out and attaching it so the court can know you're doing the best you can to meet the challenges that are there. Because the court is kind of looking to see, are there any problems here that we can help with? They're not trying to second guess you or play Monday morning quarterback. They want to know if there's some help that they can provide, because the court is also very aware of the extra resources that sometimes need to be available in the situations that your young person is facing. Okay. Let's move on to the next one. Record keeping. Now, the court doesn't want you to run out and buy a 3-drawer file cabinet and put a bunch of apples in the bottom, just so that you don't think that's being recommended. The court's telling you here there are some records that you should keep that you may need over the course of your guardianship. For some of you, your guardianship could go a long, long time. So the court says school records, like copies of report cards, or if there's specific things going on that with the school and the school is helping you with something and you get information from them, you might stick those in a file also for a while. Medical records, certainly. Legal records, probably the only ones you need are the ones that you use to obtain guardianship, and keeping copies of your annual report, for example, so that you know what you said last year. Then this one on the bottom is very interesting. It says visitation with parents or other family members, and the court says keep a journal. I think that's excellent advice. And what I suggest is get one of those 3-ring binders, that have the individual pages, and essentially keep a diary. Reader's Digest version, but put down doctor's appointment, met with the school counselor, visitation with dad at this time, and make a note or two of how that went. Did the child get picked up on time, returned on time? Were they okay? Was there something going on there? Are you having problems with this visitation thing? Probably, if any of you are going to have difficulty as a guardian, this is the most likely area that you're going to have difficulty with. There's going to be differences of opinion about visitation. How much, when, how, all of those things. What I want you to know is two things. First of all, it's your call, period. You have been given that authority by the court. And second, I want you to know the court wants to support you in the decisions that you make. We're not asking you to make perfect decisions. We're not asking you to keep everybody happy. That's a pretty tough job. But what we are asking you to do is make a judgment. Is this visitation in my young person's best interest, how it's going? And if you have to pull back the reins and tighten up visitation until the boundaries are respected, then you have the authority to do that. And if you keep a journal and someone decides to take you to court because they think you're not giving appropriate visitation, now you'll have a record of all the dates, how they went, the consequences of those things, what you tried to do to set reasonable boundaries, how that back and forth went. And the reason that's so important is if you keep a record by date and you do it conscientiously, that now becomes something called a business record under the law, and it's considered to be evidence of what it states. So if you have a relative that thinks you're not giving enough visitation and they file a motion with the court to review visitation, and they're coming in and saying this and saying that, and you stand up and give the judge your journal, the judge can consider that as actual evidence versus the verbal accusations that someone else may make. And the court will back you up if you keep those kind of records. All they want you to do is make a good faith effort to do what you think is best for the child. Hope this doesn't become a problem for you, but if it does, and if you've got those kind of records, the court now has another tool to support you. Okay, let's go on. Guardian of the estate. Okay. Well, this is not going to apply to very many of you because most minor children don't have an estate. They may have some clothes or toys or things that belong to them, but very few of them have bank accounts or investment accounts or own any significant property. But if they do, then that means you're going to be charged with managing that for their best interest. So they're stating down here that if you're the guardian of the estate, there are going to be some consequences in managing that, so the court knows that that's being handled properly. Notice down at the bottom here, it says a bond may be required by the court to protect the assets of the estate. The amount is set by the judge. That's one option that the judge has. The judge has another option, and one that I like better, and that's not a bond, but it's called blocking. The judge can authorize you, if the minor person has an account, to block that account to the extent that you don't need access to it. And to the extent that an account is blocked from your access, you do not have to bond that account. Bonding can be expensive, it can be difficult. If you can do a block instead, that's advisable. Now, if you're a guardian of an estate, you'll be presenting something to the court every year about how that estate is going, so that if you need to get into a blocked account to withdraw some money to provide for any kind of support for your protected person, that's the time you get it for the coming year. And you can do that year after year after year, and you'll find that process works pretty good. And if something happens before the year and you need to get to that asset, you ask the court's permission. You give the court something that says, we need access to some of those funds because there's been an extraordinary expense, and you tell them what it is, and the court can authorize that. So All of these things that are here are not meant to make it difficult for you as guardian. They're really here to support you and make sure that you're not only getting what you need to help that younger person, but also nobody's going to come back and second guess what you're doing because it's all under court supervision. Okay, let's go to the next slide, Edith. Inventory and record of value. So if you're a guardian of the estate, you're going to do two things. Within 60 days of getting your letters of guardianship, you must file an inventory that basically says, here's what I have, and you list it. Now, these are the things, again, that are of significant value. They're not like clothes or video games or things like that, but they're things of more substance. So the court will begin to understand what kind of estate are you managing for this younger person. Now, I also want you to be clear that we're not talking about income. So if your younger person gets any form of income, any kind of government benefits, any kind of support, when that comes in, it's income. When it goes into an account, then the account is what the court's going to want you to say, all right, here's what's happening with the income that came in. So you don't list income on an inventory, but you will show it when you get to doing the annual accounting. Let's go to the next slide. Aha, the annual accounting. Don't be intimidated by this. It's not that big of a deal. It is important to the court, and we have to make sure it's done. But it's simpler than what you may think. There are forms available on the website, warshawcourts.com, that you can print off and fill in, and that will satisfy the requirements of an accounting. The time for filing is 1 year after you received your letters. You must file an accounting of what's happened during that year. And it's really pretty straightforward. You start off with the inventory that says, court, this is what I started with. And then you say, I received this, I spent money for this, and here's what I've got left over. And I'm proving that by giving you copies of bank statements or whatever it is to show that those assets are still in the young person's accounting. So the court will look that over. If they have questions, they'll let you know. It's really just a matter of keeping track of the financial things that you do. So that means if you go out and buy school clothes, keep a copy of the receipt. You'll be using that and you'll put that under the category of clothing. Or if there's medical expenses or those sorts of things, it's actually pretty straightforward. I just don't want you to be intimidated about it. And if you keep decent receipts and records, it'll be easy for you to do. When it's time for the accounting, and it's been that first year, you still have 60 days before you have to file it. So you essentially have month 13 and month 14 to put it all together and then go e-file it, and the court will then review it and tell you whether or not it's approved. Pretty straightforward stuff, actually. Let's go to the next slide. Here's our bookkeeping slide. The bookkeeping, if you have the guardianship of the estate as part of your responsibility, is keeping bank statements, child support payments. There's an interesting one. Well, we have a specific slide on that one, and we'll come back and cover that one. But if you're receiving child support, yes, you need to track it because it's considered a form of increase in the estate. Social Security like SSI or maybe SSDI, yep, you'd keep a track of those as well. Any other income, including gifts from relatives, et cetera, you're tracking purchases and bills paid. You're actually like running the business of your younger person. Consider it to be a little business. And you're just keeping track of what's going in and what's coming out and what's left. So, and if you just stick stuff in a manila folder, you'll be able to get that out and put it together. If you have a lot of it, try and keep it up month to month so the end of the year won't be such a big deal, but it's really pretty straightforward. Okay, Let's go to the next one. Now here are some things that the court requires you to get approval of. And it says moving out of Washoe County. So if you move from Reno to Sparks, the court doesn't need to get approval, but it does want you to tell them so they know where your young person is living. So in the first part, you just provide information to the court of what their current address is. Now, what if you move out of Washoe County? Do you need court approval? No, you don't. What if you move to Verdi? Do you need court approval? Yes, because Verdi is in California. So here's the thing. Your letters of guardianship were granted by a Nevada court. And that's the limit of your letters of authority. Literally, if you leave Nevada, your letters of guardianship are not legally effective. They may or may not be recognized, but your authority is limited to the state in which it was authorized. So the court wants you to get approval if you move out of state. Now, again, they're not trying to micromanage how you live your life or where you decide it's best to live. They're actually trying to help you, because if you move to another state, you're going to need the authority to get your younger person in school, perhaps medical treatment, other things. So the court wants you to come to them and say, I'd like to move to Pennsylvania. What the court can do for you here is they can give you an order saying it's okay for you to take your guardianship to Pennsylvania and move it there. Now, at least in that circumstance, you have something from the court giving you authority to head to Pennsylvania and seek out a guardianship there. And most governmental bodies, medical personnel, school districts will recognize that it's going to take some time for you to get the Nevada guardianship transferred to Pennsylvania. But you have your ticket giving you that time to do that and some authority as best that the court can. So that's why the court wants you to get authority if you're moving out of state. Now, that's also important if you leave the country for vacation. Let's say you decide to go to Mexico. The court doesn't necessarily feel that it needs to grant you authority to go on vacation. That's not what they're trying to do. Again, what they want to do is this. They want to give you something saying, we recognize you're leaving the country on vacation and going here. Because if, again, you get in that foreign country and your young person needs medical care or something else comes up with the authority, you need to be able to show the authorities, hey, I have legal authority over this young person. I'm entitled to have them in my custody. If you can't show that in some countries, you can be arrested. They will think you're kidnapping that younger person. So again, what the court is trying to do is help you out by giving some evidence that the court is aware of this and that you're entitled to do this. So the court can also move pretty quickly, because if you haven't planned this for months and you're just going to pick up and go in a couple of weeks, if you get a hold of the court, they'll do everything they can to accommodate you and try and protect you as the guardian of your younger person. Next category. The court wants to be notified if your younger person receives an inheritance or the settlement of a personal injury claim or something like that. Again, the court's not trying to micromanage what you do, but the court wants you to be aware that you have certain options with regard to how that is handled. Let me give you an example. It very well could be that your younger person may be receiving some kind of government benefit. For many government benefits, they're what they call means-based. That means the benefit that your young person receives is based on the income that they receive. So if they receive an inheritance or a settlement, in the eyes of the government, that's considered to be income that may disqualify them from receiving benefits. That's not a good thing for two reasons. Number one, that could have been prevented. Number two, having lost benefits, frequently what then happens is you have to start over at square one after the money is spent and requalify, perhaps under different or more additional or difficult rules. Another bad circumstance for your young person. The court might be able to tell you about some options so you can avoid having your young person disqualified for a particular benefit. The point I'm continuing to make throughout this, and I hope you get what I'm saying here, is the court is your friend. It's an ally. It wants to support you in what you're doing. And you have to just give them a chance to do that, and they'll show you that they can and will. Now, the next category, extraordinary medical treatment. Well, we could spend a lot of time on this one, but basically we're trying to get our arms around what is extraordinary. Is having a tooth removed extraordinary? Probably not. Tonsils out? Probably not. But at some point, when the medical treatment gets more and more serious, we step into a range that the court considers to be extraordinary. Certainly, if a limb is going to be amputated, if there's any kind of surgical procedure that carries any significant degree of risk of loss of function or cognitive capacity for that younger person, the court's saying, please come to us and let us have some insight into this procedure. Now, again, the court is not trying to second guess your decision about what is appropriate medical treatment for your younger person. But again, what you will find when you look behind this is the court is actually trying to protect you. If you make the decision for some medical treatment and the medical treatment goes haywire and you have not gotten the court's approval, you may be subjecting yourself to litigation. Someone may think they shouldn't have made that decision. It was a bad decision. If you get the court's approval, now you have an insurance policy because someone with a lot of authority has given you the okay. That's the best you can do. Now that frees you from liability there. Okay. Next category, reunification with family. This is one that just naturally happens in many circumstances. It starts off with increased visitation, maybe, Christmas break, fall break, Easter break, summertime, and the visitation just keeps expanding to the point where, maybe everybody thinks, well, let's just let them go back and live with mom or dad. That may happen, but the court wants you again to bring that back before the court and let the court weigh in on that, because the court wants to look at what were the circumstances that caused the guardianship in the first place. Have those been addressed? Are they present any longer? Is there a present justification for reunification? Well, if you just let that happen without getting the court's approval, and then something happens with your young person when they're in one of their processes of reunification, who might be responsible for that? Yep, I'm going to tell you to look in the mirror because it's you. You're still the guardian. And until the time when you are no longer the guardian, you're still expected to make decisions that are in that young person's best interest. So don't subject yourself to that situation. Go to the court, get their opinion and or advice, their order, whatever you can get to support the action that you feel is justified. Last category, termination of guardianship. We talked before about someone being under the age of 18. If your young person all of a sudden has their 18th birthday and you think, oh, guardianship is over. Nice knowing you, live long and prosper. You're going to have a problem with that because your responsibility as guardian is to get the court to release you of that guardianship responsibility. You want to say, my younger person now is of the age of majority. They're out living on their own, living their own life, and I want to be released of my responsibility of being a guardian. And the court will do that. Same thing if you want to extend the guardianship and that person is over the age of 18 but still in school or working with a special school plan, you'll want to get the court's blessing in continuing that guardianship. Okay, let's go to the next slide, Edith. Okay, here's our child support slide. If you have a child that has a living parent and you are their guardian, under Nevada law, you are entitled to receive support from any parent of that child, just like normal child support. Now, most guardians don't realize this, or they think it would be a futile act because maybe the persons that were the parents before don't have means of support or aren't able to provide financial support. But what I want to share with you is, as a guardian, you still have a responsibility to get a support order. And this slide tells you how to get that so that it's clear that your child is owed support from any parent that they still have. Now, there may be nothing collected, but if you don't do that, and one of the parents receives an inheritance or gets a personal injury settlement or something like that, now you have no basis to go back and get the support that that child was entitled to that may provide for their college education or a number of other things. Now, many of you will have an objection to this by saying, well, gosh, if I do that, I'm going to be looking like I'm the bad guy trying to prosecute or persecute a parent. That's not true. And if anybody says that to you, you can say, I was told at the training for my being a guardian that one of my duties is to obtain a support award from the court so that I can properly protect my young person. And so you need to do that. And the information is on this slide about how you do it and where you go. And these people will help you facilitate getting a support award. Great. All right. Edith, if you're there, let's go to the next slide. Here's some areas of help. The Children's Cabinet, great organization. Child care referrals, counseling services, family resources, been around for a long, long time. Very well established, very good reputation for providing solid resources and help. A new one relatively in the area is Foster Kinship, and they give you a phone number down there where you can get a number of things that you can get support and help with as well. And let's go to the next slide, Edith, on this one. And of course, the Second Judicial District Court, Department 14 for you folks now, and Nevada Legal Services that's putting on this presentation, their address and phone number, and also the Washoe Legal Services. There's also some online resources if you want to look. There's www.guardianship.org. That's the National Guardianship Association's databank of resources and forms. So if you're ever looking for something interesting, you can do that, or you can go to the Nevada Guardianship Association as well for additional resources. Okay, let's see where we're at now. I think we're now at a point where we can ask questions. And I think, Edith, are you going to tell them how to do that, or do you want me to? You're on mute, Edith.
Okay, let me see.
Okay.
If we have any questions.
Okay. For those of you that have questions, if you haven't used this software before, if you click the bottom of your screen, some buttons will come up, and about in the middle of the screen is one that says chat. And when you click that, you have the option of chatting with a particular person or chatting with all of you all together. And you could go into there and type in a message, and hit enter, and everyone would see the message, and then I do my best to try and address it if you want to. And Edith, I didn't cover this at the front. Is there a way for them to obtain copies of the PowerPoint presentation that we just went through, or were those already sent out? Okay. It looks to me like Edith has potentially signed off.
I'm here, John. Can you hear me?
Oh, yes.
Sorry, I was getting some feedback on the background from the live video, but it
Oh,
looks like we don't have any questions on there.
okay. If you do have questions, you have lots of places to connect with, and lots of people that want to help you out. Thank you so much for attending. We appreciate what you're doing for your younger people. You're very valuable, and if there's anything we can do to help you out, we'll do our best. Thanks again, and good luck with your guardianship.
Thank you so much, John.